الحمد لله رب العالمين حمدا يوافي نعمه ويدافع نقمه ويكافئ مزيده. فيا رب لك الحمد حتى ترضى، لك الحمد بعد الرضا، لك الحمد كما ينبغي لجلال وجهك ولعظيم سلطانك. سبحانك لا نحصي ثناء عليك أنت كما أثنيت على نفسك. فاللهم أخرجنا من ظلمات الوهم وأكرمنا بنور الفهم، وافتح علينا بمعرفة العلم، وسهل أخلاقنا بالحلم، واجعلنا مما يستمعون القول فيتبعون أحسنه. اللهم اجعل أعمالنا خالصة لوجهك، ولا تجعل فيها حظا لغيرك. يا مقلب القلوب ثبت قلوبنا على دينك. فاللهم لا تحرمنا خير ما عندك بشر ما عندنا. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم، والحمد لله رب العالمين. فالسلام عليكم ورحمة الله وبركاته. How's everyone? Alhamdulillah Rabbil Alameen. So we said that we'll get straight into the new lesson today, inshallah. So we're still reading Islamic contract law, right? And we are dealing with a conventional sale. And thus far, we've laid out the parts of the conventional sale. We said that you have the contracting parties, the contracted item, and we have the formula, and we've discussed all of those along with their conditions. Thereafter, we discussed the case of the contracted item being a usufruct instead of a corporeal, and we said that that is facilitated by a different vehicle, which we called hiring. Thereafter, we discussed the contracted item being usurious, right? And we went into discussions regarding the conditions over there, right? We concluded the discussions regarding that with the definition of the sale. So now, on page number 54, we have reached a discussion called types of sales, right? And so over here, Mullah will divide this, and he says types of sales in light of the cost price. What does he mean, types of sales in light of the cost price? He means that sometimes it is that a person gets into a sale and he knows what the cost price of an item is, and he knows the markup of the item. And at other times, he gets into a contract wherein he doesn't know the cost price, nor does he know the markup. Right? So these are different types of sales. So the reason why Mullah is making this distinguishment is because he wants to discuss one of these types of sales. So over here, this is not isti'ab. We will not encompass all these types of sales. Rather, we will list some of them, and then we'll discuss only one or two types. Right? And that's how the book is set up. So he says that, oh, noble student, when you visit the retail store and acquire your desired item for a specific price, let's say 100 rands as an example, you do so understanding that the seller likely obtained the product for less and is selling it at a higher price to earn a profit. Right? Such a transaction where the cost price, profit or loss remains undisclosed to the buyer is termed as musawama sales. Right? So musawama, you can translate it as bargaining. Meaning what? That the price is up for dispute. The price is up for dispute. Why? Because the buyer doesn't really know what the cost price is, right? Nor does he know what's the profit or loss. So he tries his luck in terms of that, right? So those are normal sales. So he says that when we look at the price being disclosed and the price being not being disclosed, then we'll have different categories. The first category is musawama, and this is the most common type of sale, where when you come to the store, you don't know the cost price of an item, but you don't really care about it. You know that you are paying more for the item than what you got it. Keep this in mind. You know that you are paying more for the item than what it originally costed, right? So keep this in mind. This is a musawama sale. This is the most common type of sale, and we never have a problem with it. We never have a problem with the fact that the seller is making a profit, that he is selling this item to me for more than what he paid for it. We never have a problem with that. Keep this in mind. Then the second type, where the buyer is unaware or is aware of the seller's capital, can be further classified into three types. And we are only going to discuss one, so I'm not even going to get into the definitions of others. We have murabaha sales, we have tawliya sales, and we have wadi'a or hatita sales. Right? So the sale that we want to discuss in this book of ours is murabaha sales. Right? So the term murabaha comes from the Arabic word ribh. Right? And ribh means profit. Ribh means profit. In the famous hadith where the Prophet ﷺ says to the Sahabi that sells his date orchard, right? That rabih al-bay'. What a profitable sale you've made. Why? Because he sold it in lieu of the akhirah. He sold it in lieu of the akhirah. So this is a sale where the seller discloses both the cost price and the profit margin to the buyer. Right? In this type of transaction, the seller is entrusted. He gives his word and he's held to his word. Right? So normally the buyer will be commissioned. The buyer will be commissioned. So the seller is considered to be like the investor. Right? So or vice versa. The buyer will be considered to be the investor, and the seller will be like an entrepreneur. So the buyer will give the investor some money, right? He'll take that and he'll buy a known product on a known markup, and they'll split the profit, and he'll get his capital back. You understand? So the capital always belongs to the what they call the Rabbul Mal. The Rabbul Mal is the investor. So that total always belongs to him. However, they split the profit. So you can see that every element of the sale is known. Right? The ribh, the profit is not unknown to the investor, who over here is sort of the buyer. Right? The seriousness of this trust is emphasized by jurists who assert that in murabaha sales, the seller is obliged to disclose any defects that may have arisen while the commodity was in his possession by stating, I bought it for 10 rands, but such and such a defect occurred with it. Right? So what happens is that sometimes it may be that the investor makes over to the entrepreneur as such, makes over to him a certain amount of money. He buys products and they agree on the markup, they agree to split the profits. Now he comes back with less profits. So the person asks, what happened? So he's obliged to say, look, I bought it at this price, the goods were fine, it got damaged by me. So now they're going to have a discussion about that loss. So in this type of sale, right, every element of the sale is disclosed. You understand that? Now, so he says that at times negotiations between contracting parties may become intense, leading the seller to disclose the minimal profit associated with the sale. If the seller is being truthful, it is good and well. However, if he is lying, he violates the trust afforded to him. Right? So this is a separate point. This is a separate point. So Mala is saying that over here, sometimes, even in a musawama sale, a normal bargaining sale, when people are in negotiations, then a common thing that happens is that the person says, I'm making nothing. This is what? I'm making nothing. But that's not actually the case. He's making maybe 200%, and you bring him down to make 100%. There's no problem with the percentage that he's making, but there's a problem when you start lying about the amount of profit that you're making in order to secure the sale. So the Prophet ﷺ prohibited this. The Prophet ﷺ said, Man ghashana falaysa minna. Whoever deceives us is not from amongst us. Whoever deceives us is not from amongst us. Another thing that comes in relation to this is that the Prophet ﷺ would prohibit the Sahaba from swearing, from taking oaths when they were engaging in trades. Right? So the person shouldn't say, Wallahi, such and such. Wallahi, such and such. Right? This the Prophet ﷺ advises against this. Another common thing that happened, I think there was one Sahabi who says what? He says, Basal أحلى من how is it? بصل أحلى من عسل. He says onion sweeter than honey. Right? Onion sweeter than honey. This is بصل أحلى من عسل. بصل أحلى من عسل. So this is marketing. So here he was prohibited from this as well. Here he was prohibited from this as well. So here you have an example of that marketing taking place already in the time of the Prophet sallallahu alaihi wasallam, and the Prophet sallallahu alaihi wasallam regulates marketing practices by prohibiting the companions from saying that which is untrue in order for what? Rawaj, in order for the product, right, to be widely purchased, right? So this is something that we cautioned against. In such cases, where the buyer discovers the deception, he has the option to annul the sale. So if you just don't disclose the product, if you just don't disclose it, right, then the sale will be valid unrestrictedly. But the moment you deceive, right, by mentioning that which is not true, to pressure the person to buy, when they come to know the deception, then you will have the option to annul the sale, to say, look, give my money back. Right? طيب. So here we come to the reason why Mawla mentions murabaha over here. He says, and page number 55, in our time, some banks have adopted murabaha as a method for property financing, known as murabaha with a promise to purchase. They call it al-murabaha lil-amiri bishira. Right? In this financial vehicle, so there are various financial vehicles, like we said, we have the musharaka mutanaqisa model as well, which Mawla will not mention here. And I will just mention it for interest's sake. The musharaka mutanaqisa model is a diminishing partnership. So there's three contracts that take place over here in the musharaka model for financing, for example, for home financing. So you will have the entering into a partnership in order to secure the property, right? Then you will have a lease agreement, and then you will have a purchase agreement. And these are all separate agreements that are running concurrently, right? But they also separate contracts. And none of the contracts are dependent on the other. If any of these elements are not met, then they become problematic. So you cannot ensue one contract, right, as a condition for the other contract to be valid. We'll come to see this when we discuss invalid sales. So you can't say, I'll enter into a partnership with you if you buy my shares. Right? So that type of contract will be invalid. So the partnership must be signed as a separate contract. Right? The buying of the hiring of the bank's portion will be a separate contract. And the purchasing of the bank shares will be a separate contract. If any of this come together in one contract, it becomes problematic. In fact, it becomes haram. Becomes haram and invalid. Right? So, how does the musharaka model work? The musharaka model works like this. Say you locate a house. The house is, let's say the house is 2 million. Right? So you and the bank, so you approach the bank and you tell them that you want to buy this house. Right? Then after some scrutiny and right, you get to the point of commitment. And you commit to buy the house at a particular price. Right? When you buy the house at a particular price, you will have a down payment. That down payment becomes, right, your payment to secure your shares in the house. Now the bank will have the major part of the shares. Let's say you've got 3% and the bank has 97% shares in the manner in which you've purchased the house, right? Or 5% and the bank has 95%. Now, you own the house together. So when you own the house together, you call this musha', right? All of you own 5% of every part of the house, and the bank owns 5% of every part of the house. Now, you can technically split the property. You can split the property at 5% and you take yours and the bank takes theirs, but you own it together. Or you split the usage of the property. So you have 5% usage, right? And the bank has 95%. So what happens is now, once you own the house together, you hire, meaning you enter into a rent agreement with the bank to use their 95%. Right? And then you agree on a termly payment outside of the hiring, where you will purchase shares of the bank's house, of the bank's portion, so that over time you acquire more and more and more of their shares until eventually you've bought out the entire house. So that's how the musharaka model works. You understand that? So you can see that there's an extra cost. There is the idea of buying the house together, but you still incur more. You still end up paying more than what you bought the house for. Why? Because you're renting also. Right? So you're renting and you're buying the bank shares. So there's two things happening over there. You understand that? So that's musharaka model. Right? So we come to the mudaraba model that Mala mentions over here. The customer approaches the bank and gives the bank a mandate to buy a specific house. Right? The customer promises to buy the house once it is owned and taken possession of by the bank. So this is the risk of the bank over here now, right? Where the bank cannot sell the house if they don't own the house. So the customer has to promise to buy the house. But the promise is not binding. So when the bank buys a house, you can actually walk away, like technically, right? We consider it to be like unethical, because to break the oath is still bad, right? The bank sells the house with its capital, the first installment, stipulating a known profit at which it will resell, after which the customer purchases it at the credit price paid in monthly installments. So now the bank buys the house. Then the bank puts a markup on the house and sells it to you at the cost price plus markup. At the cost price plus markup. Right? Then you start buying the house via installments. You start buying the house via installments. So he says that there are several crucial points to consider regarding this type of sale. Therefore, it is essential, O noble student, to understand them thoroughly and make knowledge your fortified fortress. What does it mean, make knowledge your fortified fortress? Excuse me. That don't treat this matter with conjecture or what you imagine the matter to be. The matter is real. Right? So look at the reality of the matter. He says, there exists no doubt regarding the permissibility of murabaha. However, some scholars do consider it to be khilaful awla. To use this as a model for this means. Murabaha is a type of sale and it's not a loan. So when you go for murabaha financing, this is not debt financing. It's not debt financing in the sense that you taking a loan from the bank. You're not taking a loan from the bank. Right? You commissioning the bank to buy something and then you buying it from the bank. Therefore, the laws governing usurious loans do not apply, since they only come about in the case of usurious loans. So riba is not a question in murabaha, just as riba is not a question in musharaka. There's no elements of loaning. Therefore, there's no possibility for riba. There's no possibility for riba. It's not even a question. So over here, I'm going to read this because Mala goes on a bit of a rant. As discussed earlier, the concept of usury in sales cannot apply. As discussed earlier, the concept of usury in sales cannot apply here. This is because usury arises only when two commodities from the same category are exchanged or when commodities share the same ratio legis, as we discussed in the previous classes. Does murabaha sales fit any of these descriptions? By the Lord of the Kaaba, it does not. Right? That's how the sentence reads. There's an exclamation mark there. It is simply the sale of property at a credit price. In a credit sale, it is permissible for the credit price to be higher than the cash price, as it remains a conventional sale not subject to the conditions for usurious transactions. So remember what I said before, that you know that the shop is making a profit. When you go there and you buy your bar one, you know that the shop is making a profit. When you go there and you buy your car, even if it's a used car, you know that the guy got it for less. When you go and buy your phone, you know that if you buy it cash, you will pay less than if you buy it credit. You know that. And you've never been having a problem with this. Ever. I've never heard any person say, "Yeah, but the phone is going to cost more if I buy it by contract." I've never heard any person say that. Never. Ever. So, what's the difference between murabaha? What's the difference between murabaha and your phone contract? What's the difference? There's no difference. In murabaha, the cost of the house is known, the markup is known. Right? In conventional sales, many times you know what that thing costs wholesale. Like if you go to the grocer, right? To the supermarket, to the corner store. You go there, many of the items you know what the price is. But you're prepared to pay the markup. You also know that when you go to the garage, because all the other shops are closed, that you're paying more. You know that. But you don't bat an eye about it. How then can one equate murabaha financing with usurious loans when they are worlds apart? So listen to this. Oh, noble students, I attentively listened and heeded the words of Abdullah ibn Munir when he visited us at the MJC, saying, only two types of people equate Islamic financial vehicles with conventional banking, and the second of the two is the worst of them. The first is simply ignorant. He says, it's the same thing, but he has no knowledge. The second is a disbeliever. Asserted to by Allah's words, وَأَحَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَى. Allah has made trade lawful, and murabaha is a type of trade. وَحَرَّمَ الرِّبَى. And He made riba unlawful. To equate what Allah has forbidden with what He has permitted is tantamount to disbelief. May Allah protect us. Right? So we mentioned this 2 days ago, that this thing of saying it's the same thing is problematic. It's deeply problematic. It's not the same thing. Right? They are worlds apart. As we said before, that what counts is the underlying contract. When the underlying contract changes, then the hukum, the ruling regarding that changes. Right? The reason I mentioned the statement here is to emphasize the seriousness of the matter. Therefore, exercise caution and refrain from hastily labeling individuals as unbelievers. So he said, don't go around saying, when you hear somebody saying this, then you quickly say, you're a kafir. No, that's not why Mala mentioned this here. Mala mentioned this here. Why? Because he wanted to display the seriousness of the matter. Right? Especially since most people are unaware of the issue. So most of the time the person says this not because they actually disbelieve, but because they're ignorant about how the vehicle actually works. Right? And that's why they say, Man salla salatana wastaqbala qiblatana fahuwa minna. Whoever prays salah with us and he faces the same qibla as us, he's a believer. So don't go around calling people disbelievers. Okay. So we get to the next part, objections to murabaha sales. Right? After we have agreed upon the previous points, I would like to address some issues and plausible objections regarding murabaha. Right? For example, this configuration of murabaha involves the sale of a commodity not owned by the seller, as the bank sells the house before purchasing it. The noble Messenger ﷺ proscribed the sale of that which one does not own. And we previously discussed that such a person is referred to as a fuduli. Remember when we were discussing the conditions for the contracted item, then we said it must be owned by the seller or by the not by the agent. It must either be owned by the seller himself or it must be owned by the one on behalf of whom the agent is selling it for. Understand that? The legal solution to this is for the bank to acquire the house with the option to terminate the sale. Right? So meaning what? That you get this. The bank The bank buys the house conditionally, right? If the customer does not proceed, then when the customer decides to purchase the house, then the bank ratifies the sale. So the bank makes like a provisional purchase, right? Then, if the customer decides to buy the house, then the bank ratifies the sale. If not, then they can decide to terminate the sale, right? Or they can sell it to someone else, right? However, if the customer does not proceed with the purchase, the bank retains the option to terminate the sale at its discretion, right? In this form, murabaha can be considered a type of debt financing, right? While it is permitted in Islamic law, it is not viewed favorably, right? So he says that from one perspective, you can also construe this as a debt financing. Why? Because the person is going to pay the house off. But still, it can't be equated to a usurious loan because it's not a loan, it's a credit sale. You understand? So when we speak about debt financing, normally we speak about you take out a loan and then you get in debt with interest. So over here, it's a different type of debt where you have a debt, but there's no interest connected to it because the debt is in relation to a credit price that you have to square. So you can see the difference, right? So at best, they will say, look, I said it's not viewed favorably. That's like khilaful awla. It's better not to do it, right?
So Russell came to you for power in the day. He said, no, I don't have power now, but I'll sell it over 4 months. But then I'm going to sell it to you for 750. Equal increments of 250, 250, 250. The 3 increments of 250. They're fine.
Question after class. There are other spurious objections, right? So these are the two objections. The one objection is that there's a possibility for the bank to sell something that they don't own, and we've discussed the solution to that. The second thing is that from one perspective, it's a type of debt financing, but still, it's not a usurious loan. Got that? Then, there are other spurious objections that you, O noble student, should not be misled by. So now, this objection is the most common one. One of these objections is the assertion that the amount paid for a murabaha sale equals the amount paid with a usurious loan, and that the usurious loan is used to calculate the profit margin of the murabaha sale. Right? I say, and success is from Allah, the fact that the price is the same does not necessitate that the ruling should be the same. Just because you have the same price doesn't mean it has the same ruling. Rather, the ruling is based on the underlying contract. Murabaha is a valid and permissible contract. As Allah says, أَحَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَى. Allah has permitted the sale and prohibited usury. Right? There's no issue with using the usurious loan as a measure to determine the credit price. This is because the value of the usurious loan represents the credit price. Right? If you were to buy that house cash, right, then you would have had no need to go to the bank. Then there would have been no need to involve a third party that doesn't want to give you a loan. So they'll say, you know what, I'll buy it, then I'll sell it to you to make some money off it. Right? So if you weren't in need, you would have gone and buy the house at that price. But since you are in need, you need to go to somebody and tell them, look here, man, buy the house. I'll buy it from you. The person says, I don't want to buy a house. They say, give me a loan. They say, I don't want to give you a loan. It's okay. Then you can sell it to me at the markup. Then they put the markup up. How are they going to calculate it? They're going to look at how the value of that house is going to increase according to the market. And that increase in value is determined by what? By interest. It's determined by interest. So that's the measure for inflation. It's the measure for inflation. So the person who's going to sell it to you, they're not going to sell it to you at today's price because you're not going to give them the money today. So they're going to set up a credit price. And in order to measure that, they're going to look at the market. And the market, unfortunately, is determined by riba, by usury, right? So that is used as a measure for the market value by the time you square up the house, and that becomes the markup, right? This is because the value of the usurer's loans represents the credit price, which takes inflation into consideration. That rhymes a bit, eh? Which takes inflation into consideration, right? Additionally, some scholars say that having a measure for the price is better than having no measure at all, which would leave no limit for what could be charged. So the fact that there is a parallel, right, it gives the Muslim bankers like incentive to stop at that point. Otherwise, they could have charged you much more. You understand that? Whereas by interest, you fix the price and then you kind of know the rate. You understand? Whereas in the murabaha, the person can say, look, I'll sell it to you for double. So the fact that there's a measure for the price makes it easier for buyers to feel like they're doing something normal. But no, Muslims are happy with this. We want to buy houses for cheaper than kuffar because we Allah's special children on the earth. Right? I don't know what world that is. So all the objections is done. Right? So the reason why I'm saying this with tongue-in-cheek, because Mullah wrote this with tongue-in-cheek. Right? And it's very important to appreciate, number one, the efforts that scholars have gone through in crafting these vehicles, and number two, the seriousness of these discussions, Okay. So now we go to options. We go to options on page number 59. What is options? Options is what is, the Arabic term is khiyar. The Arabic term is khiyar. So, while it is true that the trade is not valid unless the mutual consent exists between contracting parties, the Sharia takes an additional precautionary step to ensure absolute certainty of mutual consent. This is done by granting both parties khiyar after initiating and enacting the sale. There are three types which we will explain. Right? So I'll explain them now in general. So you get khiyarul majlis, khiyarul shart, and khiyarul aib. So khiyar is the option to terminate the sale. To terminate the sale. The Prophet ﷺ says, Al-bay'ani aw al-mutabay'ani fil khiyari ma lam yatafarraqa. That the two contracting parties have the option to terminate as long as they have not separated. Right? So this is what is referred to as khiyarul majlis. Khiyarul majlis means that as long as the person or the persons are in the contractual sitting, then they will have the option to terminate the sale. Right? Even though the money has been exchanged and everything, they will have the full right to terminate the sale and decide, I don't want to go through with it. Right? Conversely, they will have the option to ratify the sale. Right? Like alzamtul bay'. If one of them says that, then it's done. Then it's done. Meaning now he cannot terminate the sale, but the other person can terminate the sale. If they both ratify the sale, then none of them can terminate the sale, even though they're in the majlisul aqd, in the contractual sitting. So what is the contractual sitting? The contractual sitting refers to them being physically together. As long as we can consider them to still be together, that they haven't parted ways, there's no distance. There's no distance mentioned, right? But if we consider that they have parted ways normatively, then that the khiyarul majlis is finished. Then the khiyarul majlis is finished, right? Then you get khiyarul shart, right? Khiyarul shart is when they are in the khiyar majlis, when they're in the contractual setting, then in the contract, one of them or the two of them can stipulate to have the option to terminate for between 1 and 3 days. Right? So they can stipulate for up to 3 days. They'll say, look, I'll buy this product from you, but I take my khiyar for 3 days. What does that mean? That means that they have the right to come and annul the sale in that period. And it doesn't have to be based on the fact that there's a aib, there's a defect, or anything like that. So the difference between this and khiyarul majlis is that khiyarul majlis is a right attached to the sale. It never falls away. until they have parted ways or they verbally give it up. The khiyaru shart is not like that. Khiyaru shart, right, must be mentioned. If khiyaru shart is not mentioned, then you don't get khiyaru shart. Yes, you must mention it in the contract. If you don't mention it, you don't get it. Right? Then you get khiyarul aib. Khiyarul aib is the right to return upon finding a defect. So once a person finds a defect in a product, right, then they will have the right to return. So that's called khiyarul aib. So Mala is going to explain all of these in detail. So we explained what khiyarul majlis is, right? And we said that, remember, honorable reader, this action is not considered a breach of trust, as the Sharia permits it. So the person cannot say, but you didn't just bought the thing now. The Sharia allows me this. I bought the thing, I gave the money. No, never mind. You cannot look down on the person for that. Why? Because the Sharia gives them the right to do that. The Sharia gives them the right to terminate. Right? And the risk is in the hands of Allah. Risk is in the hands of Allah. So here Allah has given both parties this, the right to terminate at this time. The person can also decide, he can, for example, you're selling your phone, you're in a time of need, the person gives the money. You get the idea, oh, I forgot about this money that I had over there. You know what? Never mind. The person can't say, no, you already bought it. No. The Sharia allows this. The Sharia allows this. Right? And then the person doesn't say, oh, this way and that way, and oh, trust in Allah. And no. The Sharia allows it. It's the end of story. Right? Remember, honorable reader, that this right has been granted to both parties by the Sharia. Hence, they are entitled to it regardless of whether or not they explicitly make mention of it.
So you can't say in the sale, for sale.
So you're going to force your question.
Oh, I thought you should give the
Question after class, inshallah. Yeah. So here are some of the benefits of khiyar. Khiyar has been legislated because the buyer may, and the buyer here is mentioned by way of example, right? Meaning the buyer and the seller get khiyarul majlis. The buyer or the seller or the buyer may purchase something impulsively without due consideration. So a person may make an impulse buy, and then they decide, you know what? I shouldn't have bought it. Right? So the Sharia takes that into consideration. Or they may purchase something on account of an impulse stemming from incessant marketing, resembling subtle coercion. You remember we mentioned subtle coercion when we spoke about the conditions for the contracting parties, the absence of coercion without just cause. Then we mentioned 3 types of coercion. One of them is subtle coercion, which doesn't invalidate the contract. So the person can be subtly coerced via marketing. This is soon after which he realizes that he made a bad choice and was not in need of the commodity. That happens a lot, isn't it? So the person, sometimes you buy something because the person is so incessant, right? Or the person may be an individual who is easily duped in matters of buying and selling. So for these reasons, the Sharia gives us a flexibility in the contract, right? Gives. You guys sitting in the class? So relax, it's fine. Right? So the Sharia gives this flexibility because of this is the nature of the buyer and this is the nature of the seller. You might buy something impulsively, right? As long as they are both in the contractual sitting, which is the place where the sale is being enacted, where the sale is being enacted, they both have khiyar. As an example, if I were to sell you my pen in my shop and we walk to your car together, my right to khiyar remains as long as we have not parted ways. You got that? So the khiyar is not the place. The khiyar is the idea of being together. You understand that? So as long as they have not parted ways, then the khiyar remains. But the moment they part ways, then the khiyar falls away. Khiyarul majlis. Right? To apply the rules of khiyar, this is an interesting one. To apply the rules of khiyarul majlis to technological advancements and online buying sites, we simply need to search for them in their respective chapters in the books of jurisprudence. So over here, we don't have to invent anything else. Why? Because when the early jurists discussed the contractual sitting, their discussion was not limited to two people being physically present in the same space. Rather, they would say, were they to shout to one another from a distance while enacting the sale, khiyar applies to them and remains as long as neither of them leaves their place. So if I was here and a person was at the door of the masjid and we enacted a sale via shouting with one another, right? Remember that the exchange doesn't have to take place immediately, right? So if we did that, then both of us will have khiyar as long as we have not moved from our places, right? Now the distance takes the place into consideration. So as long as you are in the place where you were when you shouted, then you will have khiyar. When you move, your khiyar is lost. You understand that? However, if one of them moves a distance that would be considered a separation, if they were physically in the same place, khiyar falls away. Right? So, how big is a store? By the time you, between the counter and exiting the store, it's maybe less than 50 steps. How many steps would you estimate, Ibrahim?
20 meters.
20 meters, about 20 meters, right? So if we consider that to be the separation distance, then if we were not in the same place and I moved my 20 meters, I would consider my khiyar to be gone. All right? In some books, they will explain, if I was sitting here and I moved from my seat, then my khiyar would be finished. They would also speak about, so it is clear that khiyar applies even when the contracting parties are in two different physical locations. In fact, Ibn Hajar says, this is Ibn Hajar al-Haytami, the great Shafi'i scholar, whatever distance is between them during the contractual sitting forms part of the contractual sitting. So it does not impact khiyar at all. So this entire distance becomes the contractual sitting. Does Mullah mention this case here? Okay, Mullah doesn't mention this. I think a better example would have been the case of writing a letter. So if you enact a sale via writing a letter, right, and somebody's in a different place, when they get that letter and they accept the sale, then the sale is ratified. So they accept the sale, then they send it back. When does your khiyar last? For as long as you're sitting where you accepted the sale. When you move from where you accepted the sale, you don't have khiyarul majlis anymore. You understand that? So how does this work on an online site? Khiyar will apply as long as the buyer is sitting in the same place where he accepted the offer after receiving the letter. Oh, Mullah does mention it here. Similarly, O noble student, consider the case where the contract is executed through writing a letter. Khiyar will apply and remain as long as the buyer is sitting in the place where he accepted the offer after receiving the letter. Let it not slip your mind, honorable student, that this type of khiyar applies to all types of sales, whether it be currency, staple foods, forward buying, or any other form of transaction. So, as long as they haven't parted ways, it will remain. Right? That means that in the case of a purchasing website, the contractual sitting and consequently the option for khiyar will end once the payment is made and the page is closed, as this is the prevailing norm, and Allah knows best. So, khiyarul majlis has not been measured by the Sharia. Therefore, we go to trading norms in order to measure when it ends. Right? So, what is the trading norm of a site? When have you left the online store? When you make the purchase. Once you make the purchase, you left the online store. So you don't have khiyar anymore. So over here, Mullah added once you close the page. Once you close the page, that's the khiyar is done. Right? طيب. Okay, I think that's what we have time to get into today. Yeah, I'm going to take 2 minutes. And I'm going to say that then you get khiyaru shart, right? Khiyaru shart is the option to stipulate 3 days for the person to think about it, whether or not they want to keep the item or they want to bring it back, right? So There's a hadith about this. Hibban ibn Munqid says, he came to the Prophet ﷺ, he said, "O Prophet of Allah, I'm easily duped." Then the Prophet ﷺ says to him, when you transact, say, La khibala. All right, no cheating. And I have the option to terminate for 3 days. So the Prophet ﷺ taught him to stipulate khiyar al-majlis. Right? Listen to this. In our time, under the Consumer Protection Act, the seller is obligated to clearly state the period for khiyar al-shart, or the option to terminate, which is normally 7 days. So that comes on every slip. Sometimes they give you like 40 days or something like that. Like in the bookstore, I know that they give you 40 days. So if you, how many days? It's 30 days in the clothing store. In a normal store, they give you 7 days. Right? So they give you 40 days in a book. You can actually buy a book, not bend the cover, read it, and then give it back. Right? During this period, the buyer has the full right to return or keep the commodity. According to the Shafi'i school, khiyar al-shart cannot be extended beyond 3 days. So what's the ruling? Answer and success is from Allah. We are Shafi'is in body and spirit. However, our allegiance to the Shafi'i school does not prevent us from accessing the mercy and expansiveness contained in the other schools of thought. Collectively, it's supposed to be collectively, the 4 schools of thought serve as a practical solution to the contemporary challenge we face in the field of contracts and finance. So, our honorable student, the solution lies in the entire Sharia, which is not confined to one school of thought in exclusion of the others. Rather, it is encompassed within all the schools. So, our honorable student, when the need arises for us to appropriate an opinion from another school, we find that doing so brings about ease for the Muslims in their transactions, especially in the case of those things that the general public are afflicted with. So, to get back to our discussion, some Hanbali scholars, as well as Abu Yusuf, Muhammad ibn Hassan al-Shaybani, the 2 co-scholars of the Hanafi madhab. So the Hanafi madhab is not like the Shafi'i. I'm not going to get into it. As well as Shaykh al-Islam ibn Taymiyyah, hold the opinion that khiyar al-shart may be extended for whatever period the contracting parties agree upon. So this opinion in the Hanbali school, the Hanafi school, as well as according to Ibn Taymiyyah, even if it is for more than 3 days. So we can apply this opinion of theirs to the case of the Consumer Protection Act, and Allah knows best. The next discussion is going to be food stewards. So we'll get to that tomorrow, inshallah, and then hopefully we can complete the other 20 pages. Right? So we suffice for that portion of discussions. Sallallahu ala Sayyidina Muhammad wa ala alihi wa sahbihi wa sallam. Alhamdulillah Rabbil Alameen. Then we're open for questions. Ibrahim.
So ask 4, 5 now, or give me chances?
Yeah, let's hear one first.
For sale, we mentioned like most people say non-refundable, especially for second hand. Because now, or does the person have the right to before the 3 days or now after? I don't like this mattress, so give it.
So non-refundable means that you can also refuse khiyar. You can also so khiyar is an agreement. So if one of the parties say, "Okay, no khiyar," they can refuse khiyar. Yes.
They can.
Yes.
The seller, the buyer.
Yes.
Refuse to?
Refuse khiyar. So you have to agree on khiyar al-shart.
Okay.
But you don't have to agree on khiyar al-majlis. So as long as you're in the contractual setting, you can give it back, according to Islamic law. But they're not obliged to give you 3 days.
Okay.
That you have to come an agreement on.
Next one is the camera again. So 3 months. I say you're selling 500. You have cash right now. You have 250. Yes, I can pay 250 now. Next month 250. The following month 250. So you're outright saying I'm going to sell it to you at a higher price because of getting installments.
So the question is that if you want to sell this camera for 500 rand, it's a bargain. However, the person only has 250 rands now. So you tell them, okay, give me 250 now, 250 next month, and 250 the following month. Right? So is this type of sale permissible? Yes. What will be better for you is to say, you know what? I'll sell it to you for 750. You can pay me off. Not the lay-by. Credit sale.
You can't stipulate the term because now it's.
No, you can stipulate the term.
But if you break it, you can't like count it down.
No, you can. They agree upon it. So you can agree upon installments. You can agree upon installments. It doesn't have to be a lay-by. It can be a credit sale. But what is safer and clearer is for you to say, look, this is the end price. So the credit is completely fine as long as the end price is known when you conclude the contract. Right? So when you say 250, 250, 250, you mean 750. Right? So that sale will be valid.
What can I slip in one? Like, how do we go?
Let's take Islam is one.
In the previous lesson, I think one has said there's a preference of Muraqabah over Mashar. Can you remind me why? Because of today's lesson, it sounds like there's a lot of comparisons for the latter two loans. I just want to understand why you chose the one over the other in terms of the benefits.
Yeah, that Maulana didn't disagree with me. My opinion is not important on the matter. That's up to you. The question is that previously I said that I prefer mudaraba over musharaka mutanaqisa. Right? So he wants to know why. So I said to him that, first of all, the first sign that you shouldn't take my opinion is that Maulana them, like Mullah Khalil, for example, disagree with me. He feels musharaka is better. And secondly, my opinion is not important on the matter. You can, it's up to you. They are equally halal. No, that's the model. It's a novice thing. Musharaka mutanaqisa didn't exist in the Sharia. Musharaka existed, and then we used the musharaka in a particular way, and we called it musharaka mutanaqisa, diminishing musharaka. Right? So, but it never existed as a financial vehicle. I think partnerships always existed, and there's a plethora of laws around it. Right? But this manner of using the musharaka is novice. You understand that? So normally partnerships would be like to turn over money and things like that. It wouldn't be a means for somebody to buy something off. Right? Right. Are we going to go like a person, Ibrahim?
I don't know.
Okay.
You mentioned forward buying sales. Isn't murabaha the same, or is murabaha the version of what falls under forward buying?
Murabaha is not forward buying. Murabaha is like investing. It's a type of investment structure. It's not really. It's investments essentially. So it's not forward buying. It's more like the idea of you don't have murabaha in the Shafi'i madhab is actually called qirab. It's called qirab, right? Different from qard. So qirab is this person has skills, no money. This person has money, no skills, or no desire to turn their money over. So this person approaches this person and they say, you know what? Let us, you give the money, I'll turn the money over, and then we split the profits in a particular way. That's the original configuration of murabaha, and that's how it exists as a vehicle in the Sharia. That vehicle is then used in order to create a financing solution for housing and cars. You understand that? So it's not really forward buying.
Make a profit on the forward buying, like the interest, what you call it, markup. Not like the way you.
Okay, so I see what you're saying. So a person uses forward buying as a means of making money. So yeah, I suppose they're similar in that sense. The only difference is that with forward buying, there are other utilities with forward buying. For example, forward buying in the Shafi'i madhab would accommodate something called istisna in the Hanafi school, which is what? which is manufacturing. So forward buying is sometimes you don't have something, but you can procure that item, but you don't have the money. So what do? You sell that thing to the person descriptively. You describe it, right? And then they give you the money cash, and then you go and buy it. Right? But still, this is a musawama sale. Why? Because they don't know the price of the product. And they're not interested in the markup that you make. But when it comes to mudaraba, they know the capital, they know the price of the product, they know the markup, they know the profit, and you split the profits. You see the difference between that? Right. Hope so. That's some points of difference. Right. We'll take Ibrahim on.
So paying online, as not just for you paying online or driving, is that or that we do technical?
No, it's not. I think it's an interesting one. I think as long as you're in the car, I would say. As long as you're in the car, you have khiyar.
Let's speak on half an hour.
Bismillah.
You use Hiyab to push the price. So guy comes to you in the mall.
Can you use khiyar to push the price? Okay.
So he comes to you, you're selling this item for 50 rand. Then comes in with big pack quickly, comes back. It's like, okay, I want to buy 75 rand. Left. So you say, no, but it's 50 rand. I said, no, but you left. This deal is over. The price has gone up.
Yes.
After 2 p.m.
Yeah. But you can do that. Is it ethical? I don't know. But you can do it. You can certainly do it. Right? The person who owns something is always the master of the price. It's important to understand that. The person who owns something is always the master of the price. Just take on the visa and then Ali Sabs and then yours. What was mentioned in the previous class? Okay. That's why I must come to all the classes.
Understanding of the Islamic finance models you described, but going back to usurious loans, is the main crux of the problem that it's an interest rate that can fluctuate and you don't know what the end price is that in that range. That the main problem was there other problems that they really does that to really concern where you do the ordinary.
The main problem is that loans as a contract is not meant for profit. Whether the profit is fixed or fluctuating, it doesn't matter. The main problem with financing via loans and adding interest is not the fact that it's fluctuating or fixed interest. That's not. The interest is the problem in and of itself, regardless of whether it's fixed or fluctuating, regardless of whether the outcome of that interest is known or it's unknown. The problem is the interest. You understand that? A credit sale is when the price is known from the offset. There's one price, right? Yarhamukallah. That one price is then split up into payments. That's one thing. Interest is when I borrow you something and then you promise to give me the likes of that back. I borrow you a camera, not to use, that's your camera. You must give me another one. That's your 100 rand. You must give me another 100 rand. You understand that? That's your laptop. You must give me another laptop, the likes of it. That's loans. So the moment you stipulate 10 rand on that, that's interest. The moment you stipulate 1 rand on the 100 rand, that's interest. You understand that? What's the difference? The difference is that interest is not a profit-making institution. I mean, Loans is not a profit-making institution. That's the difference. Allah has made the vehicle of sales for making money. And Allah has made the vehicle of loans a charitable institution. When you take this as a means of making money, Allah dislikes that. That's the difference. You understand? Yes, I know that you can fix interest. It's still problematic. Why is it problematic? Because you're taking a loan. You're taking a loan. You see, what's the difference between a credit price? The credit price is the fact that there's no. Now, I'm talking about practically speaking. Practically speaking, in the credit price, there's no third party. I mean, in the credit price, there's no third party. So when you go and buy your cell phone contract, you don't go to the bank. But when you buy a house, you go to the bank. Why? Because you're first taking a loan, you're going to pay interest on that loan, and you're paying for the house cash. So the house is the cash sale. You have interest with the person who loaned you the money to buy the house. Whereas in the credit sale, there's no third party. You're buying it at a higher price that you're paying off yourself. You owe no one but them. You got that? That's a big word. That's an essay, man. Would society solve any of the would Islamic financing solve the problems that interest creates? Yes. If you want a yes no answer, yes. 110%. You understand? But I know that you want the explanation. That's an essay. You don't see the benefit in not being at war with Allah? No, that's finished. There's no discussion after that, Habibi. There's no discussion after that. Otherwise, we get into Aqidah issues. You understand? So, from the Aqidah perspective, what is good and what is bad? What is good is what Allah makes permissible. And what is bad is what Allah makes impermissible. La ghayr. Nothing else. Right? So there's benefit in following the command of Allah. And there's harm in not following the command of Allah. La ghayr. There's no discussion besides that. In fact, I don't have to give you the essay. Did you read my paper that I sent in the group? You doing no work? Sleep in the one class. read it. We wrote some things over there, right? I'm just joking with you, right? So we friends. He's like at Mizan longer than me. So we read the paper, inshallah. But there is like we were reading the other morning off class. Mufti Taqi Uthmani's Mufti Taqi Uthmani's he was mentioning, we were reading it more in relation to Forex, right? But the discussion came up. So we wrote the paper, but I tried to find the paper, but it's actually not a paper, it's a book, right? And then the book wasn't available in PDF, where he speaks about Azimatul Maliyah, the money crisis and Islam's solution to it, right? So perhaps in a few, I don't know, when it will become relevant to me again. But if we get the opportunity, then we'll pen something specifically regarding how Islam would have helped the money crisis, and we'll have a discussion about it. No. With the murabaha contract, can you change the profit as you're paying it off?
So, like for instance, Musharraf contract you can change.
Yes. The murabaha is more stable.
So the Murabaha one you can't change.
No.
And then on that, if you take it like over the period now,
They can be like musamaha, they can cut the price. So they can cut the price,
when you say cut the price, you mean
decrease
decrease it,
the price.
but you can't increase it.
They couldn't increase the price. Yeah.
And then the second thing is that in that contract, who holds the risk of an asset? So the say for instance, I buy a house. So it's a 20-year period, say for instance. Now, where does the risk lie?
So the question is, where does the risk lie? My understanding of the contract is that the risk lies with the bank.
So ownership only transfers to the purchaser on the last payment.
Technically, he's only fully entitled to the house when he's paid it up. Because as long as he hasn't paid it completely, then there's kind of a right of repossession. Not in the strict sense that it will be repossessed, but in lieu of him owing that, they will take it and sort of sell it in order to squeeze debt, type of thing. The problem is when he owns most of the house, can they repossess it at that point, where the value of what he owes is far less than what he has paid? Like, let's say he's got like a year left to pay the house, and he cannot pay any longer. That presents issues, because the house is more his than it's not his. But at the same time, he hasn't paid it off. Now, so over here, can they take his house to pay that debt? I would argue not. Because remember, once the bank sells the house to him, he owns the house and he owes them money. He doesn't owe them money. I mean, he doesn't owe them the house. Understand that? Whereas in the Musharaka model, he doesn't own the house. You understand? In the Musharaka model, he doesn't own the house. But in the Murabaha model, he owns the house. Whether he gets the title deed or not is like inconsequential. The model necessitates that he owns the house. And then he owes them the price of the house. Whereas in the Musharaka model, he owns a part of the house, and he's renting a part of the house, and he's buying parts of the house. So there's more moving parts, but it's more open to like the ideas of repossession. Whereas in the Murabaha model, it's clean cut. The house is yours. You in debt. You can basically take zakah to pay the house off. If you reach that point, you can take a 1.5 million zakah and you can pay the house off. Understand? طيب.
How does guarantees and warranties work?
Mm.
The second one with the Murabaha, I understand the thing that Warren explained about you can actually use the interest module in order to get to your client.
Your credit price.
I have a problem with it. I can't see that how the bank becomes truly a owner in order to sell it back to you. Can you explain how does the bank really become a true owner in order to because the bank don't actually enter into any deal
Was it- So,
I will sign that certificate.
hmm.
Right? Doesn't negotiate anything with the seller.
In murabaha. Repeat the question.
So what makes a bank to become a true owner of the property or to sell it to you?
Yeah, like we said, that's a contention that they have with murabaha. That the bank is selling something that they don't own. That's like the solution that is mentioned is that the solution that is mentioned is that the bank like almost provisionally purchases, like we said. That like, they don't make a full purchase. Man. You understand that? Then when you agree to buy, then they agree to buy like completely. It's it's like it's gentlemen's agreements in order to get to the point where you want to get.
He's also does the if he should open does that he's owned by it's somewhere within the house.
I don't know. I don't know. Like I don't know how the bank construes the contract at that point. Like when you've identified the house and that, at what point do they own the house or not, and how exactly that takes place? I don't know. Right in the conventional uh, banking models that you're speaking about. Right. So in other places, for example, like Malaysia and that, these models work as the textbook says because they have like Islamic banks. Whereas over here, we don't have Islamic banks. We have conventional banks wherein we try to push Islamic vehicles, man. So the vehicles are open to compromise. The vehicles are open to compromise. But it's not because the vehicle is not airtight, man. It's because the banking system is uncompromising in having these type of things. So they are, I would, for lack of a better term, say holes in the setup of the contract, especially when it finds itself like in a conventional bank. But when these models find themselves in like IOFI banks, and if you know IOFI, then it's much different. It's more to the book. You understand that? Oh, the guarantees and the warranties. Look, I always forget the difference between a guarantee and a warranty.
Actual product warranty is the way of camera will have a warranty. Carry to be like something on some other like before item.
So a guarantee is like a money back guarantee. If it breaks,
You have the option to, like, say, pay on the money back.
yeah, that's khiyarul aib, essentially, kind of. So you can construe it as khiyarul aib in the sense that the the khiyarul aib, did we discuss it in detail? It will come tomorrow. It will come tomorrow. Because it speaks about like that if by default the product doesn't normally have that default and you come to find that default, then you can take it back. Even if it's after a year. You understand? So over here, they're telling you, listen here, this product doesn't break in this period of time. So when you find that it breaks, that becomes a default in the lights of that product. So then you entitled to khiyarul aib. And then warranties,
Then obviously repair the place. But now how do you repair 12-year warranty?
yeah, so warranty, I think it's more like a gift from their side. We wouldn't hold you to a warranty. But they kind of making a similar promise. They're making a similar promise in that the product shouldn't break in this time. Right? And they're allowing you to bring it back. So you can construe it in one sense or another as also khiyarul aib, because the product shouldn't break. And if it does, then they'll repair it for you. So you can construe it as that, or you can construe it as an outside like gift service, which is not a problem. Right? Alisa behind you.
No, no, I just wanted to maybe just using some of the topic in terms of the clarification.
Mm.
Mona did mention it earlier when you were speaking, but I think the fundamental crux of the difference between like taking an interest-bearing loan or a fixed interest rate versus Muhammad contract. Fundamental, just in my understanding, of fundamental difference from Islamic model is that the bank is buying it first and selling it to you. So the risk is not sitting, the risk is not only sitting with you. Now in a Musharaka contract, it's a shared risk. So like they say, for instance, you bought 50% of the house back and the bank owns 70%. You still a shared risk. You can, it's not that you owe the bank money, because they still own part of the risk. So you're sharing the risk of it. So that's my general understanding of the benefits of the Musharaka.
Yeah.
Conventional.
The buyout of the musharaka is also easier. Like in the musharaka, you can walk away with something. Because in the musharaka model, then you own a percentage of the house and you're hiring the other percent. Even if you stop hiring and you vacate the house, you still own a percentage of it. So the next buyer will only be able to buy the bank's part, and they will either have to rent the other part from you, or they will have to negotiate to buy it from you. Technically speaking.
Scenario where you have a fire, then you see the risk. And the bed is what the bank is totally on you.
Just so that it is very low on the ownership default exists.
I don't understand.
They would repossess it, but there's sort of default.
I want to be very honest with you. I have no idea how interest-bearing loan works. I've never taken an interest-bearing loan. Alhamdulillah Rabbil Alameen. I should hope that Allah will never cause me to take an interest-bearing loan. And all of this is all just this is all just theory to me. I don't own a house. Alhamdulillah Rabbil Alameen, I've never bought a car on credit or anything like that. In fact, I've never had a phone contract before. This is all theory to me. The only reason I'm interested in this is because this is the responsibility of Allah's deen. So there are many like intricate things that I have absolutely no idea about. But inshallah, this is a learning for me in the class also, that these contentions and all of that, because I will go back and I will go to the banks and I will look at the contracts more finely and see what is happening and ask the questions. But like people like our teachers that have written, I translated this book, and Ml Muhammad Carr wrote the book, and this is deep knowledge from him. He's a consultant. He's been consulting in this for years. In fact, the head of that in financial firms, in banks. And so if you really want to, you can turn your Asr class into this class with Ml Muhammad. You will get out of it much more, right? But so the best I can do is like answer according to what I know and the contracts that I have scrutinized and how they must be in theory, right? And then in practice, I think I have a lot to learn in relation to what exactly goes down and how different because different banks also structure the contracts differently. Like I said, there is the IOFI standard, which is the regulatory body for Islamic finance models. But those models normally work better in Muslim countries, especially in the likes of Malaysia and Indonesia, than they work over here, because they have Islamic banks, whereas we don't have Islamic banks. We have Islamic vehicles in banks, like I said. So yeah, that's where I am.
Think about, let's say you own 50% in the bank, and you default, you still have an option to actually sell that property, or a bank have an option to sell that property, keep this even.
You must remember also in the musharaka, I tell you this, there's something called shuf'a. Shuf'a means that first preference rights. So when you're in a musharaka, the partner has first preference rights. So if you want to sell it, you necessarily have to offer it to them first. Yeah, that's also something to think about, right? So when you co-own something, especially when it's property, right? Then the first person that you should offer it to, that you must offer it to, wujuban, wajib, is the co-owner. Either way. Either way. That's why the bank is first selling it to you and not anyone else. No matter the percentages. No matter the percentages. Right? The person must have the option for that. No. Akram? No. No. You can offer it to different prices at different to different people at different prices. Like I said before in the class, the option to determine profit is always with the seller. Always. Yes, you can. You can assign the bank as a proxy. Yeah, that can happen. But how the contract is actually construed is that the bank buys it. And then they sell it to you at a markup. Because if you commission the bank to buy it, then on what basis does the bank make money? You understand that? So you're going to come back to the problem of the bank is not there for charity. It's not a charitable institution. The bank is there to make money. Right? So the contract that the bank is going to choose is going to be a lucrative contract. If the bank wanted to, the bank would have called themselves a waqf. Then they would have given you an interest-free loan. But they don't want to. They want to make money. And there's no problem with that. Right? So, but in theory, what you're saying is correct. In theory, you could do that. But then there's no markup. Like the markup possibilities is less if none. Or if any. Right? طيب. Suffice with that. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم.